to the Accretive Employee Benefits Compliance webinar. My name is Kevin Knopf, and I am Vice President of Communications for Keenan and Accretive Company. Accretive is comprised of more than 40 specialty companies with offices in the US, UK, and Ireland. Our capabilities extend beyond traditional insurance offerings. Accretive specializes in cost-controlling solutions that encompass comprehensive enrollment services, medical stop-loss programs, and pharmacy benefits management. These services are designed to manage risks effectively while optimizing costs, ensuring that both employers and employees receive the maximum value from their benefit plans. This month, our compliance webinar series will be covering our mid-year legislative update. Presenting again today is my good friend and colleague, Amy Donovan. Amy is Senior Vice President and Chief Counsel in Employee Benefits Compliance for Accretive, and is our primary source for legislative and regulatory research, analysis, and advocacy. She's been instrumental in guiding our clients and internal teams through complex legislative landscapes and meets regularly with federal lawmakers, lobbyists, and thought leaders to discuss national trends and health insurance issues. Before we begin, I would like to remind you that this webinar is for informational purposes only and does not constitute legal advice. You should consult with your own legal counsel before taking any actions based on the information presented here. Also, please note that this webinar is being recorded and will be available on the Accretive website, as well as the Keenan website and some of our other Accretive agency websites after the webinar. It may take a day or two to get it up there. We will also provide the webinar slides for your reference. If you have any questions during the webinar, please type them into the Q&A box, and we will try to answer them at the end of the session. If we don't have time, we will publish questions and answers after the fact. Without further ado, hand it over to Amy.
Thanks, Kevin. We have, it's a deceptively short list for the agenda today and a lot to talk about. So we'll get straight to it. We're going to give you a federal compliance update, talk about some upcoming deadlines and some recent changes, talk quite a bit about potential federal changes in both the budget reconciliation bill that's making its way through Congress, as well as some executive orders. We'll talk about what's happening with state law regulation of health plans, and we'll finish today with a federal compliance calendar for Q3 and Q4 of 2025. We may not discuss that calendar in any detail, but I wanted to make sure to include it for you folks to have after today's presentation. With that, let's talk about federal compliance. We're going to turn first to mental health parity, because this has been an area where we've been getting some questions, and I want to make sure that everybody is on the same page with regard to what plans are required to comply with right now. In May of this year, May 15th, the tri-agencies, that is HHS, the Department of Labor, and the Department of the Treasury, released a statement that they would not enforce the 2024 final rule on mental health parity and on the Mental Health Parity and Addiction Equity Act. That position was in reaction in part to an ERISA Industry Committee lawsuit that was filed in January that challenged certain provisions in that guidance, including the meaningful benefits requirement, the requirement that comparative analyses include outcomes data evaluation, and that it include a certification of the fiduciary to the plan. Those are the portions of the guidance that the tri-agencies are now saying they will not enforce. There is much, if not most, of existing guidance on mental health parity that is still in effect. And I want to make sure that employers and brokers and consultants understand this. The Mental Health Parity Act is still fully in effect for financial limitations, quantified treatment limitations, and non-quantified treatment limitations, as well as the 2013 final rule on mental health parity. What's also still in effect is the CAA 2021 requirement that plans perform or obtain a written comparative analysis of their non-quantitative treatment limitations. That provision has not been stayed. It is still a statutory requirement for plans. And what's also still in effect is the April of 2021 FAQs on non-quantitative treatment limitations. And I provided a link in the presentation to that guidance. I want to be clear that self-funded plans still have an obligation under federal statutory law to obtain or perform a comparative analysis of your non-quantitative treatment limitations. There are certain aspects of that comparative analysis that that you do not need to have in the analysis itself. So you don't have to right now address the meaningful benefits requirement, provide outcomes data evaluation, and it does not need at this point to have a fiduciary certification. All other provisions, all other requirements are still in effect. So moving from mental health parity, let's talk a little bit about Medicare Part D. This is not a new change, but it is a change that's coming up. So I wanted to make sure that everybody is aware of it. I think you all know that all employer-sponsored plans are required to disclose to Medicare-eligible individuals whether the prescription drug coverage under the plan provides creditable or non-creditable coverage when compared to Medicare Part D. Employers are also required to report that information to CMS in the first 60 days of each plan year. Now, prescription drug coverage is creditable when the actuarial value of the coverage provided under the plan is at least equal to the actuarial value of coverage provided under Medicare Part D. In order to figure out whether that is the case, a prescription drug plan or a plan providing prescription coverage will either use a simplified determination under the rules or an actuarial determination. So what has changed in the last year is that CMS has revised how you are to do a simplified determination. Under the rules as they currently exist, you can use the old simplified determination for plan years beginning in 2025 or 2026 in order to determine whether your plan is creditable. But after plan years beginning in 2026, so for plan years beginning in 2027, you're going to have to use the revised simplified determination. Let's talk a little bit about the details of those determinations and what this means for your plan. So under the old simplified determination, a plan is creditable if it provides coverage for brand and generic prescriptions. It provides reasonable access to retail providers. It is designed to pay on average at least 60% of participants' prescription drug expenses, and it satisfies at least one of the following criteria: that the coverage has no annual benefit maximum, or a maximum annual benefit payable by the plan is at least $25,000. Or that the coverage has an actuarial expectation that the amount payable by the plan will be at least $2,000 annually per Medicare eligible individual. Or for employer plan sponsors that have integrated prescription drug plans and health coverage, the integrated plan has no more than a $250 deductible per year, has no annual benefit maximum or a maximum annual benefit of at least $25,000, and has no less than $1 million lifetime combined maximum benefit maximum. This determination may be used for plans that do not apply for the retiree drug subsidy or participate in an employer group waiver plan. The rules are being changed. And so beginning for plan years, beginning in 2027, you will have to use either the revised simplified determination or get an actuarial determination. So what's the difference between the old simplified determination and the revised simplified determination? Well, it is simpler in some ways, although probably harder for plans to pass. The plan must meet all of the following standards. It must provide reasonable coverage for brand name and generic prescription drug and biological products. It must provide reasonable access to retail pharmacies, and it must be designed to pay on average at least 72% of a participant's prescription drug expenses. That's obviously more than the 60% under the old simplified determination. An actuarial determination, which you can also obtain for your plan, it requires getting an actuary to compare the actuarial value of Part D to the actuarial value of the plan that you are testing, specifically the prescription drug plan that you are testing. Now, many employers that did find that they had creditable coverage under the old simplified determination will be non-creditable under the revised simplified determination. That is okay. A plan is not required to provide creditable coverage. What you are required to do is inform your Medicare eligibles annually of your creditable status and report that information to CMS. So we've outlined here an action plan for employers. So the first thing that you should be doing is consulting your carrier, your TPA, or your PBM to see how they will assist in determining the creditable status of your prescription drug coverage. You should just determine if the status will change for the next coverage year, and determine that if the status does look like it will change, if you will change your prescription drug coverage to ensure that your status stays creditable. These are considerations that you should be thinking of well in advance of the beginning of the plan year, really, when you're in your planning for the next plan year. And then make sure that you take extra care to communicate any change in creditable coverage status. So make sure you notify your Medicare eligible individuals that their prescription drug plans no longer meet the standard for creditable coverage under Part D due to these new final instructions, and by delivering the non-creditable coverage notice to your Medicare eligible individuals. So with that, I'm going to turn from Medicare D to PCORI fees, which I hope most of you know are due at the end of July. This is mostly an issue for self-funded plans, fully insured plans. These fees are paid by the carrier. But employers with self-funded group health plans, including level funded plans and HRAs, they must file Form 720, and sorry, it says 722 there, that's a little typo. We'll fix it before we send out these slides. Must file Form 720 and pay the fee before July 31st, 2025. The rate for plan years ending on or after October 1st, 2024 and before October 1st, 2025 is $3.47 per covered life. That is up from the prior reference year of $3.22 per covered life. There are 3 ways to determine your number of covered lives, and the plan, the fee is basically the rate times your number of covered lives. You can do an actual count, you can use the snapshot method, or you could use the Form 5500 method. Make sure that if you are required to pay this, that your plan is using all 3 methods and determining the lowest amount for you to pay as an excise tax. And Form 720 itself was revised at the end of May, and you can find it at the link in the presentation. Putting that to the side, we're going to talk a little bit about the Affordable Care Act, and specifically Section 1557, which is the anti-discrimination provision in the Affordable Care Act. It has been something of a political football for many years, really since the ACA was passed, and it continues to be an area of some uncertainty. So I wanted to walk you all through this. So covered entities are prohibited under Section 1557 from denying or limiting or imposing additional cost sharing for health coverage based on race, color, national origin, sex, age, or disability. That provision arguably was changed or could have been changed when the Supreme Court issued its decision in 2020 in the case of Bostock versus Clayton County. What the Supreme Court decided then was that it interpreted Title VII protections against employment discrimination based on sex to extend to an individual's sexual orientation or their gender identity. And therefore, they are protected under provisions that, that prohibit discrimination based on sex. In the wake of that case, lower courts have found in recent years that benefits exclusions or limitations based on sex or transgender status violated the Equal Protection Clause of the 14th Amendment to the Constitution, violated Title VII, and violated Section 1557 of the ACA. Arising out of Bostock and those cases, in 2022, the Biden administration issued guidance that stated that Section 1557 could be interpreted to prohibit covered entities from restricting access to gender-affirming care. And in 2024, the Biden administration followed that with a final rule on Section 1557, which, among other things, followed the 2022 guidance on gender-affirming care. A lawsuit was filed very shortly thereafter, and that provision was stayed nationwide. So that 2024 final rule is not in effect with regard to gender-affirming care. Now, what has happened since then? Well, there is a case called the U.S. versus Skrmetti that is arising out of Tennessee that is challenging the state of Tennessee's ban on providing gender-affirming care to minors. That case had oral arguments in the Supreme Court within this last year. We expect to see a decision in U.S. versus Skrmetti in the next few weeks. But again, that case challenged a bar on gender-affirming care in state law based on the Equal Protection Clause. What is also happening is that this year, the Department of Health and Human Services under the Trump administration has rescinded the Biden administration's 2022 guidance. So all of the Biden administration guidance on restricting access to gender-affirming care is not currently in effect. However, this is an area, obviously, where the law is changing and where there is some uncertainty. This is not a huge issue for fully insured plans. Fully insured plans will follow the mandates of the plans as they're written by the carriers in the states where they are bound. However, for self-funded plans, employers have decisions to make, and they should consider not just the current status of Section 1557 guidance, but state law, where there may be state law requirements to provide access to care, should consider the Mental Health Parity Act and the Americans with Disabilities Act as well, and consider the litigation risk in limiting coverage based on gender identity. That will obviously vary greatly from state to state and depending on the employer, but employers should be very considered in making decisions with regard to gender-affirming care, at least until we get firmer guidance from the courts. So putting aside what we currently know and what's currently in effect, we're going to spend a few minutes talking about potential federal changes. And the biggest area of potential federal change right now for employer-provided health plans is what's in the House Budget Package Reconciliation Bill. You may have heard this referred to as the Big Beautiful Bill. I think that's what it's actually been named by the bill author. We're just going to refer to it as the House Budget Package Reconciliation Bill. It passed the House on May 22nd, 2025. The process from here on out is that it has gone to the Senate, and the Senate is likely going to make changes. Any bill, any reconciliation bill only needs 51 votes in the Senate to pass and cannot be filibustered. There are limits on reconciliation bills, though. A reconciliation bill can only include provisions that change spending or revenues. And it's up to the Senate parliamentarian to enforce those rules, the so-called Byrd rule. So the Senate may very well come up with an entirely different bill, and then those bills would go into would go into committee, and the House and the Senate would hash out their differences and hopefully come up with one bill that both sides would then have to pass again. But we are at the end of the beginning of this process. So the House has passed its version. We are going to talk about what the House has decided we should be doing, because it may very well become law and will have some significant changes for health benefits nationwide. Now, what's been reported in the press is that there are significant changes that the House wants to make to Medicaid, and also some changes to Medicare. We're not going to talk about those today. We're really going to focus on the areas that have more of an impact on employer-provided health insurance. So we're going to talk about the changes that the bill has for the Affordable Care Act and for health savings accounts. And we're also going to talk a little bit about some important employee benefits priorities that are not included in this version of the legislation. So, what is included? There are a lot of provisions that expand HSA law in several ways. I'm going to go through them. I think we've got 3 slides on HSA expansion. So if this bill is enacted in this form, these provisions would be in effect as of January 1st, 2026, so for the next calendar year. And among them are provisions that first of all, certain sports and fitness expenses would be treated as medical care and therefore reimbursable under an HSA. Under that provision, those expenses to be reimbursable would be capped at $500 for single filers and $1,000 for joint filers. But that is a change to what's currently reimbursable. And a lot of these changes are going to be to expand what's reimbursable under an HSA. It would also raise annual contributions quite a bit, double them for 2026, and and that doubling would phase out for individuals with higher incomes. HSA contributions would be allowed even if a spouse has an FSA. Currently, they're not allowed for those employees. And for people 65 and over who are enrolled in Medicare Part A, they could contribute to an HSA. That is different from current law. Now, if that provision goes into effect and that individual could not use the HSA distribution to pay for health insurance, and there would be an additional 20% tax on distributions that were not used for qualified medical expenses. Additionally, with regard to HSAs, individual market bronze plans and catastrophic plans would be treated as HSA qualified high deductible plans that can be paired with an HSA. Also, certain direct primary care arrangements would not be considered health plans, and therefore the individuals that are covered under those arrangements would be able to participate in an HSA. And that is only if the fixed periodic fee for the DCP is $150 a month or less for an individual, $300 or less for a family, and it would allow those fees to be paid from an HSA. The provisions of the House bill also allow HSA contributions even if the employer provides an on-site clinic, would allow married couples over 55 to make individual catch-up contributions to the same HSA, would allow rollovers of some FSA and HRA funds to an HSA, and would allow payment of some medical expenses incurred before the HSA was established to be reimbursed by the HSA. So a lot of changes to HSAs if the House Reconciliation Bill package provisions on HSA become law. We are watching this closely. We will, of course, keep you all in the loop if these changes become law and explain how administration of your HSAs may change. In the meantime, the House bill also proposes certain changes to the Affordable Care Act. Now, most of those changes are individual market changes, although there are some changes that have a more direct impact on the group health marketplace. First, the individual market changes. I would put those into two basic categories. There are changes that will make it more difficult to get coverage or get subsidized coverage. And there are also changes that will make it easier to lose subsidized coverage or lose coverage more generally. So among the changes that will make it more difficult to get coverage or subsidized coverage are a shorter open enrollment period for the individual market, an end to the low income special enrollment period, as well as a provision that limits the ability of federal and state marketplaces to provide special enrollment periods based on poverty status. A provision that requires additional proof of eligibility, and a provision that ends marketplace coverage for DACA recipients and limits or marketplace coverage to people who are lawfully present immigrants. These are all proposed changes to the individual market that will make it more difficult to get coverage or subsidized coverage. Among the changes that will make it easier to lose a subsidy or lose coverage are new triggers for income verification and information attestation requirements that are in the bill, as well as a discontinuation of automatic re-enrollment provisions. The impact of all of these changes, if they go into effect, has been estimated to potentially cut about a third of current marketplace enrollment. It has increased somewhat, actually significantly, over the last 5 years to 24.3 million. So we're looking at potentially 8 million people who may lose marketplace enrollment under these provisions. What other changes would be made by the House bill? Well, the other changes that impact the ACA are again put into a couple of different categories. There are a number of provisions that revive the individual coverage HRA provisions that were put into place by the Trump administration in 2019. I call this ICRAS 2.0, and the bill refers to these arrangements as choice arrangements. So the bill would codify most of the Trump administration 2019 rule, put it into statute rather than just guidance, and would also allow employees with an individual coverage HRA to use pre-tax dollars through a cafeteria plan to pay for ACA individual marketplace premiums, and would also provide a small employer tax credit. In terms of group market changes, the significant change there is one that is kind of hyper-technical, but it would change the methodology of a factor that the federal government uses in indexing the maximum annual limitation on cost sharing, the employer mandate penalties, and income thresholds for affordability exemptions. What that means in terms of practical impact is that if this goes into effect, this change in methodology will mean that more cost sharing will be passed on to employees over time. And this change will also slow the growth of employer penalties under the ACA. Lastly, the other group of changes that I discussed, I put under the rubric of culture war issues, and you'll see why when you read through these bullets. The House bill would provide no cost subsidy reduction for individual market plans that cover most abortion services, and would prohibit the coverage of gender affirming care as an essential health benefit. And certainly that has an impact for small group plans and would also currently conflict with some current state laws. So it has a potential to inject a lot of uncertainty again into the marketplace with regard to gender affirming care. Those are the provisions that are in the bill. So what's not in the bill? Well, importantly, for our employers that have high deductible plans and also provide telehealth options to their employees, there is no telehealth fix for high deductible plans in the House reconciliation bill. It's unfortunate that this does not appear to be a priority for members of Congress. Even though, I know that members of the industry have been asking for clarification and a return to the COVID rules on telehealth and first dollar coverage under high deductible plans. It does not appear that Congress is interested in making that change. There's also no PBM provision that significantly impacts employer-sponsored plans. There are provisions under the House bill that do regulate PBMs, but those provisions really only impact government-provided plans. So there's a prohibition on spread pricing in Medicaid, which is already prohibited in many states. There are provisions that require greater transparency for carriers that are working with Medicare D. And there's a prohibition on PBMs for Medicare D prescription drug plans from receiving income for services in any form other than a bona fide service fee. So while there are changes that may be significant for the Medicare plan and the Medicaid plan, there are no provisions in the current bill that impact the way PBMs work with employer-provided health plans. Speaking of drug coverage, we also have seen within the last few months many executive orders come out of the Trump administration. I wanted to discuss with you the one that he issued on May 12th, 2025 on prescription drug pricing. That executive order announced essentially a price control policy on U.S. and foreign drug manufacturers. It gave directions to various executive agencies, including the Secretary of Commerce and the U.S. Trade Representative, to take action regarding foreign manufacturers, to the Secretary of Health and Human Services to facilitate direct-to-consumer purchasing programs that sell prescription drugs at most favored nation pricing, and to the Commissioner of the Food and Drug Administration to review and modify or revoke approvals for drugs that may be unsafe, ineffective, or improperly marked. It remains to be seen how much of what's contained in that executive order can actually come to pass. I would note that the president alone has no power to dictate peacetime pricing to manufacturers, either in the United States or anywhere else. And should that actually come to pass, there's likely to be a swift litigation response from manufacturers if the Trump administration tries through executive fiat to set drug pricing. What we are most likely to see, and as I discussed in talking about the House reconciliation bill, is action with regard to pricing in the Medicare and Medicaid programs. That's the area where the federal government has the most obvious ability to control. And this does, through the executive order, the president has signaled some potential shifts that can be positive in the philosophy toward drug reimportation, in the federal philosophy towards biosimilars and 340B programs. And government program negotiation does have the potential to impact pricing more widely if indirectly. Going on the theme of drugs, I also wanted to talk to you for a few minutes about vaccine coverage. This is another area where I think we are entering a period of some uncertainty. On May 27th, the HHS Secretary, Robert F. Kennedy Jr., announced that as of today, the COVID-19 vaccine has removed from the CDC recommended immunization schedule for healthy children and for healthy pregnant women. He directed the CDC to remove the COVID-19 vaccines from its recommendations to this group. Now, usually the CDC develops recommendations on the immunization schedule in consultation with the Advisory Committee on Immunization Practices, or ACIP. ACIP was scheduled and is still scheduled to meet on June 25th to 27th to discuss their recommendations to the CDC. However, on Monday of this week, Secretary Kennedy fired all 15 members, I think 15 or 17, might be 17 members of ACIP, of that committee, fired them summarily. So ACIP currently does not have any members. And HHS is indicating that they will be quickly replacing those members, but it's really unknown how ACIP's going to proceed at the end of this month. So what impact does this have on your plans? Well, under the Affordable Care Act, certain preventive services are required to be covered without cost sharing under non-grandfathered health plans, and that includes certain vaccines. Plans must provide coverage without cost sharing for ACIP recommended vaccines. When a new vaccine is added to ACIP's recommendations, plans are required to update their coverage once a new plan year starts, following 1 year after the date when the CDC adopts the recommendation. So there's a process under the ACA where new recommendations work their way into plans. It is really uncertain right now what vaccines carriers will be required to cover. And while the current confusion really is over COVID vaccines for certain populations, understanding the priorities of the Secretary of HHS, this could become a much wider question with regard to vaccines, especially childhood vaccines. So this is an area where we are likely to see some confusion and some change in the coming months and in the coming year. That's the end of our federal compliance update. I also wanted to discuss with you some of the things that are happening in the states. So, and specifically, we're going to begin with California. There are two bills that we're watching. The first one is SB 729. This mandates infertility coverage. It requires fully insured plans in California to provide coverage for infertility diagnosis and fertility treatment, including IVF. When passed last year, in the text of the statute, it says it is effective July 1st, 2025, with some exception for CalPERS plans. But Governor Newsom's, but first of all, the governor himself, when he signed the bill, signed a signing message that said he wanted the legislation to be delayed by 6 months. And in fact, Governor Newsom's budget proposal includes a 6-month delay of the effective date. However, this is only a proposal right now. The budget must be passed by June 15th, 2025, which is in a few days. We are watching this process very closely. We will update when a bill is signed. I mean, since the slide was written last week, I can tell you that it appears that the governor's proposal will be reduced to what they call budget trailer language that will be introduced by the legislature and hopefully signed before July 1st, 2025, that will delay the effective date of this legislation until January 1st of 2026. However, that level of uncertainty has really put self-funded plans in a position where they have already included in their plans, and if they are plans that renew on July 1st, 2025, they already have it baked into their plans that they're covering infertility. I don't think that most self-funded plans will want to back that coverage out and then document that for only a 6-month reprieve. But again, we have been covering this in our newsletters on our website. We've put up a blog post most recently yesterday on this with more information, and please go ahead and look at it. And we will continue to update you on whether this changes. I mean, this is not just a problem for California employers. It's a problem for any employer that has employees in California. So I also wanted to talk about AB 2843, coverage for sexual assault victims. This requires fully insured plans to provide employer coverage without cost sharing for employer medical care and follow-up treatment for 9 months following a rape or sexual assault. It does not require a police report and does not require the charges to be brought against the assailant. This provision is in effect as of July 1st, 2025. And I want to emphasize that when I talk about plan changes being effective in state law as of a date, that means for plan years beginning on or after that date. So just wanted to make sure that everybody understood that. With regard to other states, most of the action in other states is with regard to PBMs and how they do business. And so I'm going to take you through a bunch of both enacted bills on PBMs and also bills that we think may be enacted. So the first one that was enacted is in Alabama, SB 252, which is effective as of October 1st, 2025. That was signed into law by Governor Ivey on April 15th. It broadly defines prohibited affiliate steering. It prohibits spread pricing, requires 100% rebate pass-through unless the health plan directs that the PBM retain a portion of the rebate as an administrative fee. It establishes mandatory minimum reimbursements for community pharmacies. It prohibits retroactive pharmacy reimbursement adjustments, and it applies to self-funded as well as fully insured plans. I'm going to go through similar lists for most of the other states that we're talking about. All of the provisions are very similar from state to state. I would tell you to remember that this itself, this application to self-funded plans of these provisions is an area of unsettled law right now. We've had the Rutledge decision with regard to some aspects of PBM business practices, but there are other cases, including the Mulready case, that may very well be going to the Supreme Court. So there is some uncertainty in the law right now as to how much states can do to regulate PBM practices and when those regulations will come up against ERISA's preemption provision. So again, these are state law. If they are in effect, they're in effect. But this again may be an area where we see some change in coming weeks, months, years. Arkansas has HB 1150, which was signed into law by Governor Sanders on April 16th, 2025. It is effective on January 1st of 26. It prohibits PBMs from having a direct or indirect interest in a retail pharmacy licensed by the state. It prohibits spread pricing and requires 100% rebate pass-through, and it applies to self-funded as well as fully insured plans. Other enacted PBM legislation, HB 1094 was signed into law by Governor Polis on May 30th, 2025, and is effective January 1st, 2026. I'll stop here to just note for you that I am mentioning what governors signed these bills to just let you know that this legislation is kind of unique in that it doesn't seem to come down out of significantly red states or significantly blue states, or be signed into law by one kind of governor or another. Most of the governors that I'm going to mention today are Republican governors, but Governor Polis is a Democratic governor. Governor Pritzker is a Democratic governor. And these bills and this issue really does not seem to cut along traditional red-blue lines. So it's an area where there seems to be, at least among politicians, a lot of agreement. And it is somewhat puzzling why wider legislation regulating PBMs in the employer-provided market can't get through Congress. And as I noted earlier in the hour, the current House reconciliation bill doesn't have any provisions that that regulate PBMs in the employer-provided marketplace. So, so going back to Colorado, HB 1094 starting January 1st will limit PBM compensation to a single flat dollar service fee. It will prohibit PBMs from favoring brand or biological drugs over therapeutically equivalent generics or biosimilars. It will mandate pharmacy reimbursement at the national drug acquisition cost, plus a reasonable and adequate dispensing fee, and it impacts only fully insured plans. In Indiana, SB 3 was signed into law by Governor Brown on April 16th, and SB 140 was signed into law on May 6th. So Indiana has enacted 2 PBM bills this year. SB 3 is effective as of July 1st, 2025. It imposes a fiduciary duty on PBMs and TPAs and applies to self-funded as well as fully insured plans. SB 140 is effective on January 1st. It establishes minimum pharmacy dispensing fees, will prohibit affiliate steering, and applies to self-funded as well as fully insured plans. Montana HB 740 was signed into law by Governor John Forte on May 8th, 2025. It establishes minimum pharmacy reimbursement, a minimum pharmacy reimbursement mandate, plus a dispensing fee. It prohibits affiliate steering. It has a limitation on mandatory mail order provisions in PBM contracts, and it applies to both self-funded as well as fully insured plans. North Dakota enacted HB 1584. It's effective January 1st. It essentially just extends all of its existing PBM provisions to self-funded ERISA plans. In Oklahoma, SB 789 became law without Governor Stitt's signature on May 28th. It is effective on January 1st. It modifies the pharmacy audit law. It prohibits effective rate pharmacy reimbursement contracts and applies to self-funded as well as fully insured plans. So finally, those are the bills that have been signed into law as of this week. There are a few other bills that we are watching, including SB 41 in California, which has passed the Senate and has been sent to the Assembly for further consideration. It would ban spread pricing and require 100% rebate pass-through. It would limit the ability of PBMs to negotiate exclusivity with manufacturers. It would limit PBM compensation to a fee for service and requires a fee disclosure to health plans. The only exemption in the bill is for Taft-Hartley plans, so has a potential impact on self-funded plans. I would note here that it is similar to SB 966, which passed the legislature last year, but was vetoed by Governor Newsom. It remains to be seen whether the governor would sign SB 41 if it hit his desk. However, what we are seeing in recent weeks is that there is a PBM bill currently in draft form as part of the budget trailer legislation attached to the budget that must pass as of June 15th. The budget trailers can pass after June 15th, but what we're seeing is a bill that would establish PBM licensure under the state of California Department of Managed Healthcare. California has two regulators of health insurance, the Department of Managed Healthcare and the Department of Insurance. This would put PBM licensure under the Department of Managed Healthcare. And it would require certain transparency reporting to the Department of Managed Healthcare. So it appears that the governor seems to be going in that direction when it comes to PBM regulation. However, again, there's still SB 41. I would expect the legislature to pass SB 41 this year, and then we will see what Governor Newsom does with the bill if it hits his desk. Also pending are two other states. In Illinois, HB 1697 was sent to Governor Pritzker on May 31st. Pritzker is going to sign this bill. This is really his legislation. He has already, on the day it was passed, he made an announcement praising the passage of the bill and saying that he would sign it. So all that's remaining is his actual signature. It would ban spread pricing and would require 100% rebate pass-through. It prohibits steering. It has transparency reporting requirements and limits classification of drugs as specialty. It does have an exemption for self-funded plans, so it only applies to fully insured plans. And if it is signed, which we believe it will be effective on January 1st. The last state is Iowa. SF 383 was sent to Governor Reynolds on May 14th. If the bill is signed, it would prohibit spread pricing, affiliate steering, mandatory mail order, and preferred networks. It like most of these bills, would require 100% pass-through of rebates. It would limit classification of drugs as specialty. It would prohibit copay accumulator programs. It would set a mandatory minimum dispensing fee. It would include transparency reporting, and it would apply to self-funded as well as fully insured plans. With that, it is 1:51. I have gotten through all of my policy slides up to the compliance calendar. I've done it in under an hour, Kevin. So you owe me a Coke. And so let me, since I have a few minutes that we didn't think maybe I would have, let me just take you through the compliance calendar. So this just sets forth the traditional compliance obligations under federal law for the remainder of the year. The provisions that are in, depending on how you see color, red, pink, purple, something along those lines, are for ERISA plans only. That means that for our many plans that are local government plans, they do not have to comply with those that are in that rose color. So we just got past the RX data collection reporting requirement. Next is summary of material modifications for calendar year plans. I'm going to take you through the PCORI fee, which we already mentioned, the Form 5500 filing for calendar year plans, the summary annual report for calendar year plans, MLR rebates, Medicare creditable coverage notices, which we also discussed today, summary annual reports, and medical loss ratio rebates. The deadline for Medicare Part D creditable coverage notices to individuals, the 5500 filing for those who get an extension. And let me note that these are all for calendar year plans. If you have an off calendar year plan and you have some question about what your deadlines are, please contact your consultant, and we will be happy to give you a calendar that comports to your plan year beginning date. But these dates here do not change based on calendar year. These are on plan year rather. These are the same for everybody. So December 29th, the last day for employers to distribute a portion of an MLR rebate if you receive one from your carrier. And December 31st, the gag clause attestation requirement for everyone, just to end out the year. With that, I am going to go to my thank you slide and ask if you have any questions. I would also note, I don't think we have do we have our traditional? No, we don't. So let me go back here. I do want to say that Accretive is a brokerage and consulting firm. We are not attorneys and we are not CPAs. We are not your attorney. If you have specific questions regarding the way the law impacts your plan, you should follow up with your own legal advisor. That's the short form of our disclaimer. So with that, I'm going to take a look and see if we have any questions.
We do. We have two questions, a few questions now popping up. The first one is, are fully insured grandfathered plans subject to the CMS filings?
To CMS, for Medicare D?
Yeah, the question is just simply, are fully insured grandfathered plans subject to the CMS filings? And that's the entire question I have here.
Yeah, if the question is Medicare D, which is how we discussed CMS filings, then the answer is yes. If there's a nuance here that I'm missing, or if the question is asking about something else, please send us a note and we'll get you an answer.
Next one we have here is, could you explain the phase out based on income for HSA contributions?
Okay, let me see. First of all, I would say that is that under that provision, that ability to make contributions over and above, it's a doubling of the normal HSA contributions for next year if the House bill goes into effect. It is only available to people who have incomes of a certain level, right? So at a certain level of income, I believe it's $75,000. That doubling is not quite a doubling of the subsidy, right? They start to phase out that expanded HSA contribution. I don't have in front of me what the specific levels would be. If that goes into effect, we certainly will provide all of that information to you. But just know that that provision does have an income tie, and that it becomes less generous to people as incomes go up and ends at a certain income level.
And then the last question I have here is, can you explain why Taft-Hartley plans would be exempt from SB 41?
Oh gosh, SB 41.
Yeah, that's a tougher one. That's a kind of.
Those are negotiated plans. And I think that that's likely part of the reasoning that union negotiated plans have a different status in and especially in California. But I am not certain of that, and I have not spoken with the plans with the legislation's author to know the reason of that. But certainly that's something that we can look into if that does become law.
Yeah, and it's worth mentioning that we will be providing Q&A, and any additional Q&A you have, questions you have, you can submit. And we will post those along with the video recording and the webinar deck.
Okay. Anything else, Kevin?
That's everything I have here.
Okay. Well, I wanted to thank you all for joining us today. I know this is a lot of information, and I've said uncertain a lot. I think you're going to hear uncertain a lot more in coming months and years, but as we get clarification, we will make sure to get that straight out to you folks. So thank you.
Amy, thank you very much for all the time you put into these presentations. And everyone listening, thank you for attending. If there's a specific topic that you would like Amy or any of our other subject matter experts to speak on, please submit that in the survey that you'll get after the webinar. If you have any questions that come up, you can talk to your Accretive company representative, or you can email us. You can reach me at KK, N as in Nancy, O, P as in Paul, F as in Frank, @keenan.com, and I will forward your question to the appropriate person. And I hope you all have a wonderful rest of your week.